Namaste, Namaste. Welcome to Courtroom. My name is Sahaj. I teach laws for Judiciary and CLATPG examinations here at Courtroom by TLOI Academy. And today we are going to be discussing the Supreme Court judgment on the same-sex marriage case. And primarily, I'll be teaching this from the point of view of all the possible things that the examiner can ask you, specifically in CLAT-PG. So if CLAT-PG 2024 question paper, which is set to be taking place on the 3rd of December this year, has not been set, this is perhaps the last judgment that they can extract out questions from. So this, because the question paper has to be crafted later. However, if they do not ask this in 2024, it becomes absolutely of crucial importance in 2025. This will remain as legal static GK now forever for judiciary prelims, for LLM exams such as COQP 14 under CLATPG, for ILA exam. Let us start with all of the relevant details that the examiner can possibly ask you. First is always the case name, that is Supriya Chakraborty versus Union of India. That is delivery date, as in judgment delivery date, is on the 17th of October 2023. CLAT-PG tends to ask this. However, I don't think that other exams will ask this. Other exams always tend to ask the judgment date of Keshwanand Bharti, which is 24th of April 1973, and we celebrated its 50th anniversary in this year, in 2023. And all the relevant facts from that judgment, that lecture has already been uploaded in the course. If you're watching this in the online batch, please do cover that. So this lecture is going to be covering out the length and breadth of the MCQs that the examiner can possibly ask you. So therefore, this covers case names of related and ancillary judgments, because CLAT-PG tends to ask these a lot, and this is standard static legal GK for every exam that you may be possibly taking. These questions also used to be asked in the DULLB till 2022, till the time that DULLB was alive. Now it is dead. So the classic case law named Navteej Singh Johar, and in which section 377 of the IPC, which used to criminalize carnal intercourse against the order of nature, was struck down, partially struck down in Navteej Singh Johar. And then there are more case laws that that the CJI refer to. NAS Foundation. So now we'll go into the brief legal history of such cases. So NAS Foundation versus Government of India. And now we look at the legal history behind Navteej Singh Johar as to how did we get to the stage of Navteej Singh Johar. This remains important legal static GK for any and every law entrant. So we start from NAS Foundation versus Government of Delhi, in which 377 was read down. In appeal, in Suresh Kumar Kaushal versus NAS Foundation, NAS Foundation was, the case of NAS Foundation was turned down, so the decision was overruled. And then we went to Navteej Singh Johar. However, इसके बीच में भी दो cases हो गए. That is National Legal Service Authority versus Union of India, in which transgenders were recognized as a third gender, and it was recommended that they be treated under the SEBC, socially and educationally backward classes. और उसके साथ साथ एक और केस हुआ था, that is Justice K.S. Puttaswamy, the right to privacy is a fundamental right, the Aadhaar case, more popularly known as, that's versus Union of India. So in both of these cases now, they can always ask you as a standalone question also, कि in Nalsa what was the decision? The court held that the state is defined where Article 12 Part 3 of the Constitution must recognize persons who fall outside the male-female binary as third gender persons. This has also been asked that under which category. This was asked in DULLB 21, which that time DULLB was quite an advanced law entrance, that under which category was it recommended that the third genders be placed. So that is SEBCs. Now, in Justice K.S. Puttaswamy, the court held that the Constitution protects the right of person to exercise their sexual orientation. This can be asked to you as a single liner MCQ, that in which case was it held that the Constitution protects the person to exercise their sexual orientation. That is Justice K.S. Puttaswamy, because this can be a slightly teda MCQ, you can say, because Justice K.S. Puttaswamy, you will usually remember as that is the Aadhaar case and right to privacy. However, this was also held in that case, and CLAT-PG loves to ask such random fun facts, which they also encounter because the examiner is reading these very judgments. Alright. So from, just as a summary, hierarchy में notes बना लीजिए. We went from NAS Foundation to Suresh Kumar Kaushal. Suresh Kumar Kaushal से Navteej Singh Johar पहुँचते पहुँचते बीच में दो केस हो गए. That is Nalsa वाला case and Justice K.S. Puttaswamy. Alright. And then we finally, so the request was placed before the Supreme Court that please refer this appeal to a larger bench, because Nalsa and आपके K.S. Puttaswamy has happened. So now they answered the reference, that is the larger bench, in Navtej Singh Johar versus Union of India, holding that section 377 is unconstitutional. तो नालसा में क्या हुआ था, के एस पुट्टास्वामी में क्या हुआ था, और के एस पुट्टास्वामी वाला जो फन फैक्ट that this one, that a person, the right of a person to exercise their sexual orientation is protected by the constitution. And finally, under Navtej Singh Johar, it was held that 377 is violative of Article 14, because this is also MCQ. Which article was it held that section 377 violated which article? That is primarily it's Article 14. And section 377 also classified individuals on the basis of the core trait of sexual orientation. That is, Article 14 prohibits discrimination based on sex, which includes within its meaning sexual orientation as well. So in which case was it held that the word sex? So because there are grounds in Article 15. So Article 15 has been amended thrice. That is the 93rd Amendment, sorry, the First Amendment, then the 93rd Amendment, then the 103rd Amendment, clauses 4, 5 and 6 in that order. And the grounds are R square CS POV, that is religion, race, caste, sex, place of birth. So within the word sex, you have the meaning of sexual orientation is included in the word sex. So that is, we are quickly revising Article 15. If you are in the online batch, cover out Article 15 or revise it if you haven't so already from your course. Now, after the Nalsa judgment, which law was enacted, or which of the following acts were enacted as an effect of the Nalsa judgment? I'm giving you sample questions alongside this. So Parliament enacted the Transgender Persons Protection of Rights Act 2019. Just mark out the year because this becomes important. Alright. To protect the right of transgender community and provide welfare measurement for their betterment. So statute का नाम याद करना पड़ेगा. And now the Supreme Court, primarily speaking, the CJI went into the issue of the respondents' contentions or submissions that the Supreme Court cannot hear this matter altogether because, well, you will only enforce a right under Article 32 if the right has been given in Part 3 of the Constitution, that is the fundamental rights, right? So the right to move, the Supreme Court, is in itself a fundamental right for enforcement, or if any statute is violating your fundamental rights as given in Article 13, if any act is violating or derogating your fundamental rights as promised to you in Article 13 by the state as defined in Article 12 under Part 3 of the Constitution, you can approach the Supreme Court for enforcement of those rights. So the Supreme Court went into the discussion of, after going through this brief legal history, the Supreme Court went into the discussion of whether we can hear this petition or not. Primarily speaking, एक jurisdiction का issue इन्होंने खड़ा कर दिया. तो यहाँ पे इन्होंने बताया, जो इन्होंने basically analysis करी इसकी, the word including in clause 2 of Article 32, if you can open your Bare Act to Article 32, that will be great, indicates that the 5 writs mentioned in the clause are illustrative. So can the Supreme Court go beyond the 5 writs as mentioned in Article 32? Yeah, sure. The word including is used as a word of enlargement. This court may issue directions, orders or writs other than the 5 writs specified. ये चीज़ अपने notes में mark out कर लीजिएगा. ये जो आप online batch में अगर आप इसको देख रहे हैं, so I've already marked it out for you. You can just download this PDF attached with this lecture. Alright. Now we go here. First clause 2 provides this court with the power to issue directions, order or writs, which indicates that this court may mold the relief according to the requirements of the case before it, and that it is not constrained to a particular set of cases in which a particular relief or set of reliefs may be granted. Particular relief, set of relief, Order 7, Rule 7 of the CPC, the Supreme Court is not limited by that, and as it is, you have the power to do complete justice as given in Article 142, which is Part 5, Chapter 4 of the Constitution. The Union Judiciary के अंदर आपको मिल जाता है right after the doctrine of stare decisis, that is Article 141. And why do I keep repeating this, even though this is not connected to the matter at hand, is that बार बार सुनेंगे तो बार बार you will get better at it. Alright. Put differently, this means that the power of this court is not only negative in the sense that it may restrain the state, as defined in Article 12, from doing something which infringes upon the fundamental rights as given in Part 3 of people, but is also positive in the sense that it may compel the state to do something or act in a manner which gives effects to such rights. So can the Supreme Court, so usually it is said that fundamental rights are negative rights and DPSPs are positive rights. However, under Article 32, now the Supreme Court has given a comment that they can either negatively stop the state from doing something, or they can ask the state to do something to enforce the rights of the people as guaranteed by the Constitution in Part 3, that is fundamental rights. Alright. Now, of course, fundamental rights can be amended, yes, as long as you're not violating the basic structure. That is primarily the core message of the Keshwanand Bharati judgment. And वहाँ पे भी आपके जो कहानी शुरू हुई थी शंकरी प्रसाद from Sajjan Singh, then went to Golaknath, and then we went to Keshwanand Bharati. If you're serious about these exams, all of this needs to be on your tips like this. Alright. Then the Supreme Court went into the analysis of आपका judicial review. However, I am just extracting out the most relevant MCQs that the examiner can ask you. No branch performs the functions of any other branch. That is the doctrine of separation of powers. The traditional understanding of this doctrine, also termed the pure doctrine, and examiner can ask you which of the following is which of the following doctrines is known as the pure doctrine. और अगर पढ़ा नहीं है separation of powers तो फंस जाएंगे वहाँ पे उस MCQ में. Now, in effect, our constitution does not reflect a rigid understanding of this doctrine, has long been acknowledged by this court. So Article 50 also under Part 4, that is DPSPs, that we try to keep the executive and the judiciary separate, because, well, DPSPs are not justiciable under Article 37 as well. So our constitution does not reflect a rigid understanding. However, we try to implement this doctrine as the pure doctrine or the doctrine of separation of powers as much as we possibly beyond academics can in real life. ठीक है जी. आगे चलते हैं. तो यहाँ पे इन्होंने कह दिया the separation of powers undoubtedly forms a part of the basic structure of the constitution. Write this down in your notes rather, because well, this is important. They have again mentioned it that the doctrine of separation of powers is a part of the basic structure. That is, it cannot be taken away by an amendment. The doctrine of separation of powers certainly does not operate as a bar against judicial review as well. What are the MCQs that can be asked from this? So consider which of the following statements are correct or incorrect, and then MCQs can be framed out. That which of the following was not stated in this case. So this is being stated, but however the CJI judgment is in the minority. We will sum up the judgment also किसने क्या बोला था at the end of the lecture, but firstly let us extract out all the relevant MCQs from here. Now again the CJI goes into the previous case laws, precedents, doctrine of stare decisis, Article 141. In Common Cause versus Union of India, a constitution bench of this court, of which one of us, that is D.Y. Chandrachud, found that the right to life, dignity, self-determination and individual autonomy meant that people had a right to die with dignity. So in which of the following case laws is the right to die with dignity was held as a part of fundamental rights? Article 21, of course. In Common Cause versus Union of India, ये तो सदा का standard MCQ है, that is euthanasia and living wills also. It was recently amended as well, so this becomes an important case law. As an amended, मतलब the judgment had the directions were modified slightly. In Vishaka, what are the Vishaka guidelines? Vishaka guidelines are the guidelines to protect women at workplaces, right? At the workplace, to protect them from sexual harassment. In Vishaka, this court issued guidelines for the protection of women from sexual harassment at the workplace. This is absolutely dead on simple, right? And then why are these two important is that in these two cases the court issued directions for the enforcement of fundamental rights in the absence of a law which was impugned before it, therefore proving their own point which they raised, that under Article 32, yes, we can, even if no express law is there, we can still issue directions for the enforcement of fundamental rights. Even if no specific law is there that impugns your fundamental right, we can still go ahead and issue directions for it. So both of these case laws become important from a legal standpoint of view. Judgments की list में अपनी भी standard पे आप डाल ही लीजिए इनको. Alright, now this is standard, this is asked all the time. This is absolutely, a question that has been asked 1500 odd times, I believe. मतलब मैंने गिना नहीं, of course, in UGC Net or Judiciary Pre or LLM, wherever. The Supreme Court of the United States of America established the power of judicial review in Marbury versus Madison. This is a clear-cut, I believe, MCQ. Then we go here. We'll go into child marriage also because they have entered into that domain. So I'm trying to cover out all our bases so that the examiner cannot attack us from any angle whatsoever. They have quoted a book also. They've quoted a number of works, but I believe this one is important with respect to sex. Negotiating Hijra Identity in South India. So this is written by Gayatri Reddy. Somehow, if randomly this pops up in CLATPG, you will now know the source of where this is coming in from. Now they are going into the history of child marriage, and I think I've done a lecture before also on child marriage. पढ़ा हुआ है void avoidable के ऊपर, as in on the channel. Child marriage and the age of consent. So age of consent way back then in 1860 was 10 years as stated in the judgment, and then in 1890 a 35-year-old man called Hari Mohan Maiti caused the death of his 10-year-old wife Fulmoni Das. So this is a popular fun fact from Static Legal GK. Now Fulmoni Das, जहाँ पे भी उनके आत्मा को शांति मिले, it's just such a young girl back then. Thank God that we progressed as a society. No girl, I mean, marriage at 10 years is just cruel. Through violent sexual intercourse with her. So he was having violent sexual intercourse with a 10-year-old. I really don't know how people can even go down to this level. And then after this incident, the age of consent for girls was now raised to 12. Relevant MCQ. So 1860, what was the age of consent for girls for marriage? It is 10 years. Then in 1890, as in later, the age of consent for girls was raised to 12. And then decades later, in the Child Marriage Restraint Act 1929, ये statute याद रखिएगा, the age of marriage for girls went from 12 to 14. So we started from 10, then we went to 12, then we went to 14, and later on now we'll come into 18. In 1949 rather, now 1929 के बाद 20 साल बाद I think we are now independent, but constitution has just about to commence in 1950, 26 January. Adoption enactment की date 26th November, right? And 11th November National Education Day. Maulana ये आपका Abul Azad, right? First Minister of Education का happy birthday. Now in 1949 we are at 15 years finally. So we went from 10 to 12 to 14 to now finally 15. And the Hindu Marriage Act, minimum age of marriage at 15 for girls and 18 for boys. In 1978, the HMA was amended to raise the minimum age of marriage to 18 for girls and 21 for boys. All relevant details. The Prohibition of Child Marriage Act 2006 provided that child marriages would be voidable. So as per the Prohibition of Child Marriage Act 2006, child marriages are voidable. Great. And the statute criminalizes the act of performing, conducting, directing, abetting, etc. Then, as per the Protection of Children from Sexual Offences Act 2012, a child is defined as any person below the age of 18 years. This is absolutely dead on crucial, has been asked again and again as well in every exam that you can think of, the higher level law exams. Then in Independent Thought versus Union of India, standard question hai. Basically the case was all about the inconsistency between the POC-SO Act, which criminalized sexual relations with a child, and exception 2 of section 375 of the IPC as it exists today, IPC 1860, भारतीय न्याय संहिता, तो बाद में सेक्शन नंबर चेंज हो जाएगा. तो एक्सेप्शन 2 के अंदर लिखा हुआ था कि sexual intercourse by a man with his wife was not rape if the wife was above 15 years of age. So by this judgment was the word 15 now has to be read as 18. Alright, but since IPC was not officially amended, you have to keep the judgment in mind, and this was a standard legal MCQ कि किस case में ये काम कराया गया था and what is the age. DULB was very fond of asking this question in the last 5 odd years till 2022. They mentioned it I think about once or twice. तो पहले पूछ चुके थे और उससे पहले भी एक बार ही पूछ चुके थे 2017 के बाद भी. It used to be, they used to ask quite advanced questions even in a law entrance. All right. So exception 2 was violative of 14, 15 and 21. Golden triangle revise karenge. Golden triangle of the constitution, 14, 19 and 21, or 14, 15 and 21, just creating a doubt in your head. Check it from the Menka Gandhi judgment कि वहाँ पे golden triangle क्या दे रखा है. And exception 2 के अंदर हमने, we are going to be reading it as 18 now. Okay. It is evident that the law governing marriages has come a long way from Fulmoni Das's lifetime. Then some relevant provisions from the IPC were quoted in the judgment. Section 498A is all about DV, that is domestic violence, and वहाँ पे the cruelty के basis पे जो case लगते हैं, the husband or his relative. Now many people are against this section. This is quite a popular section. And section 304B is about dowry death, and which year? That is 1986. All relevant details, all MCQs that the examiner can ask you, even if, let us say that you're taking any other exam which is primarily MCQ based and it's not the CLATPG, they can, all of these are standard independent MCQs, and they will be of this covers the length and breadth of a lot of MCQs that can be asked in every law entrance. Then originally SMA was enacted in 1872, then it was completely revamped in 1954. All of these years are important. Firstly, it came in 1872, then it came in 1954. Then you have Shakti Vahini versus Union of India, important case law, लिख लीजिए अपने notes के अंदर. This court took note of the violence against couples in intercaste and interfaith marriage. In which of the following cases the court took note of the violence against couples in intercaste and interfaith marriages? That is Shakti Vahini versus Union of India. Extremely important. Alright. And then in Shilpa Shalesh versus Varun Srinivasan, ये तो judgment आने ही वाली है इस साल के CLATPG में, guaranteed, because this is this year's judgment, in which the Supreme Court said that under the power to do complete justice, Article 142, Part 5, Chapter 4 of the Constitution of India 1950, which has now been amended 106 times. The 106th Amendment is all about women reservations. However, it will come in effect post 2029. Under Article 142, this court held that it has the authority to grant divorce when there is a complete and irretrievable breakdown of marriage. Alright, for the online batch folks, we have to discuss this judgment. I don't think that I've uploaded a lecture till date when you're watching this. However, I'll be uploading it before the weekend, क्योंकि ये वाला काम करना ही करना है. In Shaira Bano versus Union of India, that is the triple talaq case, in which, by the way, I think the CGI was again in the minority. We'll just come to that at the end of the lecture. This court held that the practicing of severing the marital bond, मैं इसको martial पढ़ रहा था, खैर can be a joke on marriage, but anyway, marital bond through the mode of talaq-e-biddat was unconstitutional. In which case was it held? Do not get confused. Shah Bano was all about maintenance of Muslim women. Maintenance is given where, as of today's CPC, is in section 125. In Shafeen Jahan versus Ashokan KM. Now, Shafeen Jahan versus Ashokan KM is the Hadia or Hadia case. I really don't know about the pronunciation of this. I think it should be the Hadia case, in which it was alleged that this is a case of love jihad. However, it was not. The Ashokan KM was Shafeen, or rather is Shafeen Jahan's father. Shafeen changed her religion to Islam to marry her husband, and in this case, the Supreme Court observed, or rather, a three-judge bench of the court observed, our choices are respected because there are social approval for intimate personal decisions is not the basis of recognizing them. Indeed, the Constitution protects personal liberty from disapproving audiences. They can give you this and ask in which case was it this observed. That is Shaheen Jahan versus Ashokan KM. Alright, so in this case the marriage was challenged by the family. Then you go to Indra Sharma versus VKV Sharma. Write this down because CLATPG tends to extract out all the MCQs from such details in any judgment. They said the issue was whether live-in relationships can be considered to be a relationship in the nature of marriage. Now, a two-judge bench of this court observed that a relationship in the nature of marriage is distinct from a marriage. So, live-in relationships are not exactly marriages. This was held in Indra Sharma versus VKV Sharma. Which of the following case laws relate to live-in relationships? This is Indra Sharma versus VKV Sharma. ठीक है जी, आगे चलते हैं. आगे Now the Supreme Court enters into constitutional theories, as in primarily the CJI enters into that, and then it says the Ninth Amendment to the US Constitution states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. ये आप थोड़ा करना पड़ेगा US की Constitution usually UGC net and CLAT loves anything relating to US law. Though the Indian Constitution does not contain such a provision, it is implied that the rights enumerated in Part 3 are not exhaustive. तो ये fun fact भी याद रखना पड़ेगा. तो similar provision वहाँ पे Constitution में उन्होंने via the 9th Amendment in the USA कहा कि भैया जो यहाँ पे लिखा हुआ है उसके अलावा भी बहुत कुछ हो सकता है. हमारे यहाँ by case laws हम बहुत कुछ काम कर चुके हैं इसके ऊपर, especially all the relevant most important judgments under Article 21 wherein different rights have been enumerated or to be held to be included under Article ये आपके Article 21. Alright, तो अब he will give you illustrations and we will extract out all relevant MCQs. So the right to livelihood is now a fundamental right. The right to speedy trial is now a fundamental right. Right to education is a fundamental right. Expressly it was made as a fundamental right in Article 21A, 86th Amendment, year 2002. सब कुछ important है. And right to education, अभी ये तीनों के case laws भी लिख लेते हैं. So right to livelihood is a fundamental right, that is Olga Tellis versus Bombay Municipal Corporation. You pretty much know this case. Hussainera Khatun versus Home Secretary and Khatri versus State of Bihar also is right to speedy trial, and Unni Krishnan versus State of AP, in which the right to education was made as a fundamental right, and then the legislature enacted the 86th Amendment or gave effect to this judgment and made the right to education for children between the ages of 6 to 14 ये आपका expressly उनको ये आपका fundamental right दे दिया गया था Article 21A में, and the Right to Education Act was enacted in 2009 2009. all relevant MCQs. तो ये तीनों चीज़ें यहाँ से हो गई. Standard legal अगर आपके MCQ भी पूछ लेगा तो चलता है. Okay. Fundamental rights are characterized as positive rights and negative rights both. In fact, some draw a distinction between fundamental rights and the DPSPs. DPSPs given in Part 4, fundamental rights given in Part 3. Part 1, the union and its territory. Part 2, citizenship. Part 3, fundamental right. Part 4, DPSP. Part 4A, fundamental duties. Alright. Now in constitutional theories, in constitutional theory, negative rights are understood to involve freedom from governmental action, whereas positive rights place a duty on the state to provide an individual or a group with benefits which they would not be able to access by themselves. Supreme Court, basically the CJI went that fundamental rights can be both positive and negative in nature. And then he remarks, this method of deriving unenumerated rights attained prominence after the judgment of this court in R.C. Cooper versus Union of India. This can be a standard static MCQ for CLATPG, that in which method, or rather in which case law was it said, or was the method of deriving unenumerated rights, that are those which are not listed in Part 3, कौन सी judgment में काम हुआ था, or method, as in method gained prominence after which judgment, that was R.C. Cooper versus Union of India, which held that fundamental rights are not watertight compartments, and the thread of reasonableness contemplated in Article 14, that is doctrine of reasonable classification, runs through Article 21 as well. Now this is extremely important because they can give you this fun fact and can ask you कि कौन सी judgment में भाई. So that is R.C. Cooper versus Union of India. Alright, now more fun facts. अभी दिल्ली थोड़ी सी दूर है, ठीक है जी. Neither the majority in Justice K.S. Puttaswamy nor the majority in Navtej, they basically, it was the petitioner's argument कि these two cases held, yeah, rather in these two cases the Supreme Court held that the Constitution guarantees the right to marry. So CJI has expressly rejected that argument, and then he goes on to state very clearly that there is no fundamental right to marry. Now we go to another US case law जो कि CLAT वालों को बहुत पसंद आएगा. That is Obergefell, if I am pronouncing this correctly. So Obergefell versus Hodges, Director of Department of Health, in which the right to marry was recognized as a fundamental right by the Supreme Court of USA. So they can give you a standard MCQ in which are the following case laws. जैसे Marbury versus Madison में तो judicial review. In Obergefell sounds better, no? Obergefell. Yeah, Obergefell sounds much more Angrezi. Anyway, I'm not sure about the pronunciation. Anyway, Obergefell versus Hodges, the Director Department of Health. In this case law, the Supreme Court of USA recognized the right to marry as a fundamental right there. हमारे यहाँ कुछ ऐसा कुछ नहीं है. Where is marriage given? That is entry 5 of the concurrent list of the 7th schedule. 7th schedule में कितनी lists? 3 lists. Union, state, concurrent, we took them from GOI Act 1935. ठीक है जी. So marriage is placed where? So of course now Parliament is making the laws and the states are amending it via local specific state. The state legislatures are amending it via their own choti moti amendments. The Constitution does not expressly recognize a fundamental right to marry. This all the judges agreed with, but there was differences because this is after all a 3:2 key judgment. Now we go to the Special Marriage Act. So he is taking on the arguments of the petitioners one by one. It says यहाँ पे a marriage between any two persons and then it is mentioned as party. So I'm in section 4 of Special Marriage Act. And then पहले तो person बोला, party बोला, so it can be construed to be very gender neutral. But then it goes Special Marriage Act में the male has completed the age of 21 years and the female has the age of 18 years. So they were arguing that this is discriminatory. It should be gender neutral so that people can marry under the Special Marriage Act. The Supreme Court said, well, that is not our job to enact the law. That is the Parliament's job basically. So section 4 of the Special Marriage Act becomes slightly important. Now the decision of the South African Constitutional Court in Fouri. Now Fouri, F-O-U-R-I, यहाँ पे होता तो चौका बोल देते हम इसको, versus Minister of Home Affairs. Fouri इसके अंदर to argue, that was the precedent that was being relied upon by आपके the petitioners, that is to argue that the provision of SMA must be read in a gender neutral manner. So case law कौन सा CLAT में ही पूछेंगे, बाकी हमारे local judiciary pre or I don't see this popping up here. That South African Constitutional Court in which case this is Fouri versus Minister of Home Affairs. This was यहाँ पे marriage के ऊपर इन्होंने बात करी होगी और gender neutral की judgment आ गई होगी, तो South African वाला काम करना है. Then CLAT loves to ask such stuff because it CLATPG almost always gives one passage on international laws. So principle 24 of Yogyakarta principles. Now India is not a signatory to the Yogyakarta principles. Principle 24 states everyone has the right to found a family regardless of sexual orientation or gender identity. So this of course relates to this case. And ये Yogyakarta principles के बारे में और एक MCQ देख लेते हैं. Wikipedia से मैंने निकाल लिया है. Yogyakarta Principles is a document about human rights in the area of sexual orientation and gender identity. Becomes extremely crucial for CLAT. If they don't ask this year, this is now forever a question for any year that is going forward. That was published as the outcome of an international meeting of human rights group in where? That is Yogyakarta, Indonesia. Alright, in 2006 and in 2017, it was amended to include new grounds of gender expression, sex characteristics. This is extremely important. The right to health, which legislation relates to mental health, that is Mental Health Care Act 2017, बस statute याद रखना, ज़्यादा और कुछ भी नहीं करना यहाँ से. And then we go here. Just standard revision, constitutional वाले modules आप section से in the online course आप already कर चुके हैं, I believe ये. Article 25 के grounds, Article 25 public order, morality, health and other provisions of Part 3. DUL will be 21 का भी question. And मेरा दिमाग बार बार वहाँ जाते रहता है. I've seen so many. I used to teach for it a lot. I know that paper inside out. So वहाँ पे दिमाग जाता रहता because they are used to ask these questions. These are standard legal MCQ questions. Then you have the Indian Young Lawyers Association versus State of Kerala, which was the Sabrimala judgment in which 5-judge bench. तो ये कितने judge की bench this CLAT almost always asks, and who gave the dissent in this? In the Sabrimala judgment, that is Justice Indu Malhotra. In the demonetization case, who gave the dissent? Justice B.V. Nagaratna, also said to be the first female CJI of India. Alright, now we go here, and they have decided or given the final decision that sex, the word sex, religion, race, caste, sex, place of birth in Article 15 includes within its folds other markers of identity which are related to sex and gender, such as sexual orientation. So now this is final. Sexual orientation has been interpreted to be under the Article 15. Thus, a restriction on the right to enter into a union based on sexual orientation would violate Article 15 of the Constitution. The CJI is saying this. This is a 3:2 judgment in which the CJI is in the minority. We'll get to the summary very, very soon. Then the courts must use the integrated proportionality standard formulated in Akshay N. Patel versus the RBI. So in which of the following cases the court propounded the integrated proportionality standard? That is Akshay N. Patel versus RBI. Alright. Standard MCQ. Now we go to pursuant to the decision in Nalsa, Parliament enacted the Transgenders Person Act. So this MCQ we've already discussed. However, no such statute was forthcoming pursuant to the decision in Navtej. So they can ask you Nalsa के बाद कौन सी act आई? That is the Transgender Persons Act. और यहाँ पे नवतेज के बाद तो कुछ भी नहीं आ पाया. They have reminded the government that please do so. Then comes in an important case law in Arun Kumar versus the Inspector General of Registration. The first petitioner was a man, second petitioner was a woman who happened to be transgender. They married each other and the Madras High Court held that. This is an extremely important case law. Arun Kumar versus Inspector General of Registration. That is, the expression bride in the HMA cannot have a static and immutable meaning. Statutes must be interpreted in light of the legal system, and the fundamental right of the petitioner under Article 25 was infringed. ये case law का नाम याद रखेंगे. Most likely it will show up in your exam. Then the Supreme Court referred to other cases that are relating to transgenders. Mansoor Rahman versus Superintendent of Police, Lata versus Commissioner of Police, Sushma versus Commissioner of Police. The only MCQ that can ever pop up from these minor case laws is which of the following is not related to transgenders. ये तीन option होंगे, वहाँ पे चौथा सा कोई random होगा. Just make a note and try to remember them. But Sushma, Lata and Mansoor all related to transgenders. बाकी वो जो चौथा option है वो नहीं है. एक दो बारी अपने आप को बोलेंगे और थोड़ा सा रट्टा मारने की कोशिश करेंगे. Can tackle out that question. Then the adoption regulations, that is delegated legislation under the Juvenile Justice Act, was also challenged. CARA का full form भी पूछ सकते हैं, that is Central Adoption Resource Authority. इसके ऊपर भी the CJI is in minority because after all it's a 3:2 का judgment. We'll just discuss that as I'm keeping on repeating. I won't go into these details. I am giving these to you in notes. You can go through it, but I don't think that truly an MCQ is there. But just for your conceptual understanding, you can go through it. That act or regulation, act के अंदर regulation बनाई जाती है. Therefore, it is a delegated legislation. Delegated legislation का standard MCQ, that is from admin law. Delegatus non potest delegare, that if you delegated some power to the other person, पंजाबी में कहते हैं नौकरों के नौकर, आगे नौकरों के आगे चाकर. मतलब तुमने नीचे वाले को काम दिया, उसने आगे किसी को सब delegate कर दिया. ये allowed usually नहीं रहता unless and until it is mandated by the statute. Then the CJI goes and decides that Regulation 5, Clause 3 of the Adoption Regulation Act regulations exceeds the scope of the JJ Act, that is the Juvenile Justice Act, and he says that CARA has proceeded under the assumption that only married couples would be able to provide a stable household for the child, क्योंकि वो guidelines के अंदर ये लिखा हुआ है कि marriage आपकी हो जानी चाहिए for adoption. तो इसके ऊपर CJI ने तो कह दिया कि this is not done. However, overall the judgment says that this is done. Alright. For these reasons and the reasons recorded in section T, etc., the CARA circular is violative of Article 15 of the Constitution. That is CJI's judgment. No more MCQs from here. Now the CJI, technically speaking, disagreed, not technically speaking, actually disagreed only with the opinion of Justice Ravindra Bhatt. This is the MCQ that CLAT can ask you. कि कौन से जज के साथ CJI ने बिल्कुल ही डिसएग्रीमेंट कर दिया. But this due respect such a narrow understanding of fundamental rights turns back the clock on the rich jurisprudence that the Indian court. तो यहाँ पे रविंद्र भट्ट जी ने क्या कहा है कि unenumerated rights are recognized by courts in response to state action that threaten the freedom or right directly or indirectly. CJI says ऐसा तो नहीं है, क्योंकि हम इसके बिल्कुल विपरीत कुछ काम कर चुके हैं in a lot of case laws in which the court has held in numerous cases held that right of persons are infringed not merely by overt actions but also by inaction. तो रविंद्र भट्ट जी कह रहे हैं कि जी फंडामेंटल राइट तो आपके जो अनएमरेटेड हैं, जो कि पार्ट 3 के अंदर नहीं दिए हुए, दे आर ओनली रिकॉग्नाइज्ड इन कोर्ट्स टू रिस्पॉन्स टू स्टेट एक्शन दैट थ्रेटन द फ्रीडम. लेकिन CJI भाई साहब कह रहे हैं कि भाई साहब ऐसा भी तो हो सकता है ना कि हमने तो यहाँ पे ये दूसरा वाला काम भी करा हुआ है. ठीक है जी, ओके. Now, so he's now giving you examples. So in Nalsa, the court held that the state, by rendering the transgender community invisible and failing to recognize their gender identity, deprived them of social and cultural rights. In this only, Justice A.K. Sikri का opinion था that direction थी rather, we direct the center and state governments to take steps to treat them as socially and educationally backward classes. This is also MCQ, कि in which class of citizen were the transgenders ordered to be included by the Supreme Court. So this is that. And in Union of India versus Association of Democratic Reforms, it recognized the right of citizens to receive information regarding criminal activities of a candidate to the Legislative Assembly. This is a standard classic case law. And then in Sheila Burse versus Union of India, the Supreme Court held that the state of West Bengal jailed persons with mental disabilities who are not suspected, accused, charged, or of convicted for committing any offense, but only for the reason that they are mentally ill. So this is extremely important. Just like वो आपकी जो इंद्र शर्मा वाली वो जो judgment थी about live-in relationships, ये शीला बरसे वाली भी become important, added to your judgment वाली list. So the CGI is giving examples कि भाई हमने तो not necessarily that we have responded only when the state has threatened. We have also responded when the state is just totally inactive about the rights that are unenumerated in part 3. Then you have state of Himachal Pradesh versus Umed Ram Sharma. In this case, a letter petition was written to the High Court claiming the construction of a road which would benefit the residents of the village, in particular the members of the Dalit community, was stopped by the state. So इसके अंदर भी it was allowed, and ये Article 21 के अंदर उन्होंने allow किया होगा. And finally, now we come to the broader MCQs that they can ask. So in this case, in Supriya versus Union of India, Supriyo या जो पहले जो alias जो लिखा हुआ था. So there were 4 opinions. It was a 5-judge bench. CLATPG tends to ask all of this. It was a 366 page की judgment, out of which 247 आपके चंद्रचूड़ जी ने लिखी है, and he disagreed with Justice Bhatt's judgment, who wrote his judgment on behalf of Justice Hima Kohli as well. जो bench के जो judges के member के जो नाम है वो बहुत important है. Justice Kaul wrote a judgment for 17 pages, Justice Narasimha for 13 pages. This is extremely important for CLATPG specifically. Usually not other exams, they do not enter into asking name of judges. All agreed. So this is the summary of the judgment. I could have given this right at the very beginning of this lecture and you would have run away. So now if you're watching till now, naman to you, you are a serious candidate, and more often than not, you will have a fair bit of more chance than other candidates in clearing your exams. So all agreed that there is no fundamental right to marriage. All right. That marriage for queer community cannot be read into the special, that is the right to marriage for queer community cannot be read into the Special Marriage Act 1954. Transgender persons in heterosexual relationships have a right to marry. This was under the existing legal framework. ये ज़रूर ही ज़रूर लिख लीजिए. And right to, so this is extremely important. Transgender persons and heterosexual in which people are of other genders, but in which the third gender can marry if, well, both are belonging to the two separate genders. Right to form civil union. This was held by 3:2 की judgment. The majority disagreed that there was no such right in our constitution. The minority, that is Justice Kaul and CJI, both were on the same side. They agreed that there is such a right. However, the others did not. And by 3:2, the adoption, the Kara guidelines are legally valid. So basically the question is, can unmarried non-heterosexual couples adopt? CJI की minority judgment में जो हमने कहा वो जी हाँ, but overall no, because well we lost out by 3. Basically we lost out by 1 judge, नहीं तो tie breaker कराना पड़ता आगे जाके. And another fun fact that the CLAT can ask कि CJI in minority. Now all of this is of course sourced from various websites, full credit to them. CJI in minority in the past decade has been in challenge to triple talaq case. CJI was in the minority. Reservations for EWS का case. This was again CJI was in the minority. Homework, तीनों के नाम, आप नाम तो खैर सेम सेक्स मैरिज का केस जो हम डिस्कस कर रहे हैं, तीनों के नाम की लिस्ट अपने एंड पे बना लीजिएगा. स्पेशली रिजर्वेशन फॉर EWS 103rd Constitution Amendment. I'm talking about the case law name. Was it Janit Abhiyan? Think about it. 101st कौन सी amendment did what? GST. all of that stuff. And 13 cases में in the past decade CGI has been in the minority, including the present one. Phew. Alright, now we wind this up. Hopefully ये सारा काम आपने कर लिया. I have tried to cover as much as I could. I've only dissected the CGI's judgment, क्योंकि बाकी में मैंने देखा ऊपर से देखा था तो ज़्यादा कुछ है नहीं, क्योंकि ये यहीं पे इतने सारे MCQ बन जाते हैं that perhaps hopefully the examiner will not get into those pages, but वो काफ़ी छोटा काम है and mainly it agrees and in portion disagrees with the CGI's judgments, and academics are quite the fanboys of the present CGI, so they will usually look at his judgment, and quite rightly so. He's quite a balanced person, and the Supreme Court didn't enter into the domain of the legislature, like it should not on most cases, unless and until the state goes berserk. And yeah, so I don't know what your opinion on the judgment really is, because this is people say कि यार ये तो बिल्कुल theory देगा ही, कुछ करा तो है नहीं. However, for the future, and secondly ये बहुत सारा काम इन्होंने बहुत अच्छे तरीके से कर दिया, and nothing is of waste. So online तो criticism आसान है. However, these guys are working really hard. And what do you think? Just comment in the comment down below. And if you watched till now, thank you so much. I appreciate it, because usually these lectures don't do very well on YouTube, because पढ़ने नहीं, मनोरंजन के लिए ज़्यादा platform in tune है. Any which way, I wish you all the very best. If you're preparing for CLATPG 2025, let us say that this does not get asked in 2024, will be asked in 2025, maybe asked in 2026, then the chances become forever, because now this is part of legal static GK. We will also offer it to our online batches for CLATPG and LLM forever now. This lecture is of utmost importance. I hope that it has been of help to you. I sincerely hope that you secure a seat in your exam. Prepare well and give it your best shot. Take care. Bye.